Hi everyone. So our topic for today is about the freedom of religion. So this is under Article 3 Bill of Rights of the 1987 Constitution. Okay. So Section 5, Freedom of Religion, which says that no law shall be made respecting an establishment of religion or prohibiting the free exercise thereof. The free exercise and enjoyment of religious profession and worship without discrimination or preference shall forever be allowed. No religious test shall be required for the exercise of civil or political rights. So our first case is Aglipay versus Ruiz. So in Aglipay versus Ruiz, here the petitioners Gregorio Aglipay, the supreme head of the Philippine Independent Church, seeks the issuance from this court of a writ of prohibition to prevent the respondent director of post from issuing and selling postage stamps commemorative of the 33rd International Eucharistic Congress. So, nagbebenta sila ng mga post stamps si Monsignor Gregorio Agripay. In 1936, the director of post announced in the dailies of Manila that he would order the issuance of postage stamps commemorating the celebration in the city of Manila of the 33rd International Eucharistic Congress organized by the Roman Catholic Church. In spite of the protest of the petitioner's attorney, the respondent publicly announced having sent to the United States the designs of the postage for printing. Okay. So, the issue here is there a violation of principle of separation of church and state? As we know, or if we should know, their church and state should be separated as stated in the Constitution. And if the freedom of religion, the constitutional right of freedom of religion has been violated. Here, the ruling of the Supreme Court was that um, the Act 4052, it contemplates no religious purpose in view. So what it gives the director of post is the discretionary power to determine whether the issuance of the special postage stamps would be advantageous to the government. Actually, the stamps were not issued and sold for the benefit of the Roman Catholic Church. And even the money was actually given not to the church but to the benefit of the Philippine government. So, the real purpose of selling the postage stamps is to advertise the Philippines and to attract more tourists to this country. So, the officials concerned merely took advantage of an event considered of international importance to give publicity to the Philippines and its people. It is significant to note that the stamps are actually designed and printed. Instead of showing as a Catholic chalice as originally planned, it contains map of the Philippines. So that was what was in the postage stamp. Okay. So here part of the ruling states that what is emphasized is not the Eucharistic Congress itself but Manila, which is the capital of the Philippines. As the seat of that Congress, it is obvious that while the issuance and sale of the stamps in question may be said to be inseparably linked with an event of a religious character, the resulting propaganda, if any, received by the Roman Catholic Church was not the aim and purpose of the government. So we are of the opinion that the government should not be embarrassed in its activities simply because of incidental results, more or less religious in character. If the purpose had in view is one which could legitimately be undertaken by appropriate legislation, the main purpose should not be frustrated by its subordination to mere incidental results not contemplated. So there is no violation of the principle of separation of church and state, and the issuance and sale of the stamps in question may be said to be separably linked with an event of a religious character. The resulting propaganda, if any, received by the Catholic Church was not the aim and purpose of the government, but rather to promote tourism. So here in Naglipay versus Ruiz, it merely shows that the government really does not support or does not did not do the selling of the postage stamps for the benefit of the Roman Catholic Church. So, the next case is Garces versus Estenzo. So, this is a 1981 case. Here in this case, there is a barangay council in Ormoc City who issued 4 resolutions to the purchase of a patron saint image which will be used for the celebration of the town fiesta. So, what they did is they purchased, or they allotted budget for an image of Saint Vincent Ferrer, or San Vicente Ferrer, in relation to their town fiestas. Okay, so what happened here was that that image, it was put into the church. So when the image was placed in the church, um, Father Osmeña, let me check on that. Father Osmeña, okay. The Father Osmeña claimed that the church owned that said image. Okay. So, consequently, the image of the patron saint had to be placed in the church when the Mass was celebrated. If there is nothing unconstitutional or illegal in holding a fiesta and having a patron saint for the barrio, then any activity intended to facilitate the worship of the patron saint, such as the acquisition and display of his image, cannot be branded as illegal. As noted in the resolution, the Barrio Fiesta is a social-religious affair. Its celebration is an ingrained tradition in rural communities. The fiesta relieves the monotony and drudgery of the lives of the masses. So the issue here is whether or not such acquisition is in violation of the non-establishment clause. And the ruling of the Supreme Court was that no. The Constitution provides that no law shall be made respecting an establishment of religion, and that no public money or property shall ever be appropriated, applied, paid, or used directly or indirectly for the use, benefit, or support of any sect, church, denomination, sectarian institution, or system of religion. The question resolutions does not directly or indirectly establish any religion, nor abridge religious liberty, nor appropriate public money, nor property for the benefit of any sect, priest, or clergyman. So the image was purchased with private funds, not with tax money. Okay. So it was purchased not with tax money but with private funds. Moreover, the wooden image was purchased in connection with the celebration of the Barrio Fiesta, honoring the patron saint San Vicente Ferrer, and not for the purpose of favoring any religion nor interfering with religious matter or the religious beliefs of the barrio residents, since Barrio Fiesta is a social-religious affair. So, Father Osmeña claims that it belongs to the church is wrong. The barangay council, as owner of the image, has the right to determine who should have custody thereof. The barangay council designated a layman as the custodian of the wooden image in order to forestall any suspicion that it is favoring the Catholic Church. A more practical reason for that arrangement would be that the image, if placed in a layman's custody, could easily be made available to any family desiring to borrow the image in connection with prayers and novenas. If the council chooses to change its mind and decides to give the image to the Catholic Church, the action would not violate the Constitution because the image was acquired with private funds and its private property. So, the Barangay Council of Valencia has the right to take measures to recover possession of the image of San Vicente Ferrer, which is its private property, from the parish priest of Valenzuela by enacting resolution number authorizing the hiring of a lawyer to file a replevin case against Father Osmeña for the recovery of the image, as well as resolution number 12 appointing Veloso as its representative in the replevin case. So, not every governmental activity which involves the expenditure of public funds and which has some religious tint is violative of the constitutional provisions regarding the separation of church and state, freedom of worship, and banning the use of public money or property. Okay, so the next case, this is an interesting case, the American Bible Society versus the City of Manila. So this is a 1957 case. Here, in American Bible Society, in the course of its ministry, the plaintiff's Philippine agency has been distributing and selling Bibles or gospel portions thereof. So, throughout the Philippines, they were translating the same into several dialects. So on May of 1953, the acting city treasurer of City of Manila informed the plaintiff, which is the American Bible Society, that it was conducting the business of general merchandise since November 1945 without providing with the necessary mayor's permit and without municipal license in violation of Ordinance number 3000. As amended, and ordinances numbers 2529, 3028, and 3364 and required plaintiff to secure within 3 days the corresponding permit and license fees, together with the compromise covering the period from the fourth quarter of 1945 to the second quarter of 1953 in the total sum of around 5,800 pesos. So the plaintiff protested against the requirement, but the city treasurer, they demanded the plaintiff to deposit and pay under protest the sum of 5,891 and 54 cents. So if suit was to be taken in court regarding the same, so now, to avoid the closing of its business, the American Bible Society paid. Okay, they paid the defendant under protest the said permit and license fees in the aforementioned amount, giving the same time notice to the city treasurer that suit would be taken in court to question the legality of the ordinances under which the said fees were being collected. So again, no, they paid upon protest. They paid with protest. Yan. Okay. So, next, the issue here is whether or not the said ordinances are constitutional and valid, because their contention is that it restrains the free exercise and enjoyment of the religious profession and worship of the appellant. So, the ruling here is that, well, it's clear that Ordinance number 3000 is not unconstitutional. So, the ordinance is correct. Um, they should be, asking for permits and licenses, mayor's fees, mayor's permit. However, that ordinance is not applicable to the plaintiff appellant, the American Bible Society, because it would be tantamount to um, restricting their freedom of religion and freedom to dissemination of their religious beliefs. So that was the ruling of the American Bible Society. So selling Bibles is not merchandise. So the next case, Victoriano versus Elizalde Rope Workers Union. So this is a 1974 case, and I believe this is also a labor case. Yeah. Okay. So the facts here is, Victoriano, he was an employee of the Elizalde Rope Factory Incorporated. As such employee, he was a member of the Elizalde Rope Workers Union, which had closed shop agreement with the company that membership in the union shall be required as a condition of employment for all its permanent employees. Prior to its amendment, Section 4 of the Republic Act number 875 allows the employer to require as a condition of the employment membership in a labor organization. So they are being required to be a member of the union to continue or to be hired by Elizalde Rope. If such organization is the representative of the employees, however, the provision was later amended by the enactment of Republic Act 3350, which reads, "But such agreement shall not cover members of any religious sects which prohibit affiliation of their members in any such labor organization." Now, here comes the revision. Okay, if for religious matters, he may, or any member of such religious sect may not be. Okay, he can choose what he wants to do. Now, being a member of a religious sect that prohibits the affiliation of its members with any labor organization because he is an INC member, or Iglesia ni Cristo, Victoriano presented his resignation to the union. And in turn, the union asked the company to dismiss Victoriano from the service in view of the fact that he was resigning from the union as a member. So this prompted Victoriano to file an action to enjoin the company and the union from dismissing him. So the union assails the constitutionality of RA number 3350, contending that it infringes on the fundamental right to form lawful associations guaranteed by the Bill of Rights. The issue is whether or not RA number 3550 is unconstitutional for infringing on the fundamental freedom to form associations. The ruling of the Supreme Court is no. As ruled by the Supreme Court, RA number 3350 merely excludes ipso jure from the application and coverage of a closed shop agreement the employees belonging to any religious sects which prohibit affiliation of their members with any labor organization. What the exception provides, therefore, is that members of said religious sects cannot be compelled or coerced to join labor unions even when said unions have closed shop agreements with the employers. That, in spite of any closed shop agreement, members of said religious sects cannot be refused employment or dismissed from their jobs in the sole ground that they are not members of the collective bargaining union. It is clear, therefore, that the assailed act, far from infringing the constitutional provision on freedom of association, upholds and reinforces it. It does not prohibit the members of said religious sects from affiliating with labor unions. It still leaves to said members the liberty and the power to affiliate or not to affiliate with labor unions. If, notwithstanding their religious beliefs, the members of said religious sects prefer to sign up with the labor union, they can do so. If in deference and fealty to their religious faith, they refuse to sign up, they can do so. So the law does not coerce them to join, neither does the law prohibit them from joining, and neither may the employer or labor union compel them to join. So, therefore, RA 3350 does not violate the constitutional provision on freedom of association. Okay. Moving on to the next case, which is our last case, German versus Barangan. So here in the afternoon of October 2, 1984, the German group, which is composed of 50 businessmen, students, and office employers, they converged at JP Laurel Street, Manila for the purpose of hearing Mass at the St. Jude Chapel, which adjoins the Malacanang grounds, located in the same street. Now, they were wearing yellow t-shirts and they started to march down, which raised clenched fists and shouts of anti-government invectives. The marchers were barred by the respondent, Major Lariosa, upon orders of his superiors and correspondents, General Santiago Barangan, from proceeding any further on the ground that St. Jude Chapel was located within the Malacanang security area. Despite plea, they were not allowed in the church because of the alleged warning given them by the Major Lariosa that any similar attempt by petitioners to enter the church in the future would likewise be prevented. Petitioners took this recourse. So what's happening here is that during this time, there are several attempts to abduct the president or the family of the president. And this German group, they were wearing yellow shirts, and it was noted that they may attack the family of the president. So the issue here is whether or not the restriction to petitioners to attend church is a violation of their freedom to religious worship. The ruling here of the Supreme Court was that the restriction imposed on the use of JP Laurel Street was established in the interest of national security. So petitioners are not denied or restrained of their freedom or belief or choice of their religion, but only in the manner by which they had attempted to translate the same into action. This curtailment is in accord with the pronounce of the court in Gerona versus Secretary of Education. And while it is beyond debate that every citizen has the undeniable and viable right to the religious freedom, the exercise thereof, and of all fundamental rights for that matter must be done in good faith. As Article 19 of the Civil Code admonishes, every person must be in the exercise of his rights and in the performance of his duties, observe honesty and good faith. Okay, so thank you so much for watching this video, and I'll be uploading more of my review sessions. Hope you like, subscribe, and you can comment down below for any suggestions or clarifications. Okay, so continuing the discussion, the basic principles of Section 5, the freedom of religion. So here, the purpose or the basic principles, first is the twin clause of free exercise and non-establishment express an underlying relational concept of separation between religion and secular government. So the concept of religion, the definition of religion has been expanded to include even non-theistic beliefs such as Taoism or Zen Buddhism. It has been proposed that basically a creed must meet four criteria to qualify as a religion under the First Amendment. So, first, there must be belief in God, moral code, sincerity in belief, and some association ties. The principle of separation of church and state is that first, there is a strict separation between the church and the state. There is strict neutrality, and there is a benevolent neutrality. In the non-establishment clause, it states that no law shall be made respecting an establishment of religion. So, usually, what is being used here is the Lemon test to determine if the establishment clause was not violated. So, there is a purpose prong. Okay, the statute has a secular legislative purpose. Effect prong, its principal or primary effect is one that neither advances nor inhibits religion. Incidental is allowed. And entanglement prong, it does not foster an excessive government, entanglement with religion. So the application of the Lemon test, for example, in Aglipay versus Ruiz, the one that we discussed earlier, the director of post announced in the dailies of Manila that he would order the issues of postage stamps commemorating the celebration in the city of Manila of the 33rd International Eucharistic Congress organized by the Roman Catholic Church. Does this violate the Establishment Clause? No, the purpose of the issuance of such postage stamps is secular, which is to promote Philippine tourism. The primary effect is to encourage foreigners into visiting the Philippines. The fact that it mentions an event organized by the Roman Catholic Church is merely incidental. And number 3, the issuance does not foster an excessive entanglement with religion. Next, is the tolerance of the DOJ is the tolerance by the DOJ of the holding masses in the Hall of Justice violative of the Establishment Clause? No, since there is no law, ordinance, or circular issued by any governmental body mandating that judicial employees must attend the Catholic Masses. The employees went to the Masses at their own will. So, you can check this decision in INRE, letter to Tony Valenciano, 2017. Alright, Section 29, Paragraph 2 of the Article 6 of the 1987 Constitution is related to the Non-Establishment Clause, which states that no public money, property, appropriated, applied, paid, employed, actually directly or indirectly, use, benefit, support into a sect or church, denomination, into a priest, minister, or dignitary. So the word apply, it means to use or employ for a particular purpose. The word appropriate means to prescribe a particular use for particular monies. Thus, the words pay and employ should be understood to mean that what is prohibited is the use of public money or property for the sole particular primary purpose of benefiting any church. Further, the phrase directly or indirectly, it refers to the manner of appropriation of public money or property, not as to the direct or incidental benefit to the church. Hence, the provision does not prohibit the use of the property when the religious character is merely incidental and not particular or primary or direct. As example, a public street may be used for a religious procession or a civic parade, and a public plaza may be used for a religious rally or a political assembly. How do we differentiate then establishment clause and free exercise clause? So, in establishment, it entails a positive action on the part of the state. Accommodation, free exercise, on the other hand, is passive. In the former, okay, the state becomes involved through the use of government resources with the primary intention of setting up a state religion. In the latter, the state, without being entangled, merely gives consideration to its citizens who want to freely exercise their religion. Meanwhile, in the free exercise clause, it states that no law shall be made prohibiting the free exercise thereof. So the free exercise, the enjoyment of religious profession, worship, without discrimination, presence forever be allowed. So there are two aspects of the free exercise clause. The first is the freedom to believe, and the second is the freedom to act on one's beliefs. So the freedom to believe, this is absolute because this cannot be a subject of a regulation because the freedom to believe is merely a thought. It's on the mind. While the freedom to act on one's belief, this can be subject of a regulation because these are external acts already. So, what is a religious speech or expression? Religious speech expression is employed by religious communities to pass on their knowledge, to negotiate their values and norms, and to relate to other religious and non-religious communities. Hence, the constitutional guarantee of the free exercise and enjoyment of religious profession and worship carries with it the right to disseminate religious information, as also mentioned in the American Bible Society versus the City of Manila. We have not discussed Diocese of Bacolod versus Comelec. So in Diocese of Bacolod versus Comelec, there is a big tarpaulin which states that Team Patay and Team Buhay. This is in relation of the family planning law. So the question is, are the tarpaulins of in Diocese of Bacolod versus Comelec um, are those religious speech, and can the COMELEC prohibit such type of tarpaulins? The ruling of the Supreme Court was that no, not at all, because not all acts done by those who are priests or any other religious make such act immune from any secular regulation. The religious also have a secular existence. They exist within a society that is regulated by law. Hence, it is not covered merely by freedom of speech, expression, and not freedom of religion. So, there are three standards of separation, as I mentioned earlier: strict separation, strict neutrality, and benevolent neutrality. So, in Estrada versus Escritor, benevolent neutrality has been discussed. So, what is benevolent neutrality? The Philippines adhere to benevolent neutrality, with religion looked upon with benevolence and not hostility. Benevolent neutrality, it allows accommodation of religion under certain circumstances. Accommodations are government policies that take religion specifically into account, not to promote the government's favored form of religion, but to allow individuals to exercise their religion without hindrance from the government. The exceptions is to the allowance are clear and present danger tests and strict and scrutiny tests. So, what are the tests to determine if the free exercise clause was violated? The first test is the clear and present danger test. So, this test, it applies if the law regulates free expression in relation to the religious freedom. While in strict scrutiny test, this is usually applicable test. So let's apply in one example. For example, Mr. A believes that Satan is a supreme being. Can the state prevent him? No, because the freedom to believe is absolute. It cannot be subject to regulation. So even if he believes that Satan is his supreme being, that Satan is God, then the state cannot prevent him. Okay. So Satanism is an organized religion in the Philippines. Some of its believers are sacrificing people to worship their supreme being. Can the state restrain this religious worship? Yes, under the clear and present danger rule, religious expression can be restrained if there is clear and present danger that it leads to a substantial evil, such as the killing of the people. So in my first example, sa una, Mr. A only believes that Satan is his supreme being and Satan is his God. So then the state cannot regulate him. But in my second question, since Satanism, is an organized religion and people would want to sacrifice another set of people or another person in order to patronize their god Satan, then it could be under the regulation of the state because it would include killing people. So Congress, it enacted a law banning Islam from their practice in the Philippines because it raises terrorists. Is this law valid? No, because there are lesser intrusive ways to prevent terrorism. Hence, the law is unconstitutional. Okay. In American Bible Society, the society versus Manila, the society has been distributing and selling Bibles in the Philippines. The city of Manila informed that it was conducting a general merchandising without procuring a mayor's permit or license, in violation of city ordinances. Was Manila correct? Okay, so this is what we discussed earlier. No, the distribution of Bibles is a form of religious expression. Under the doctrine of benevolent neutrality, religious expression must be accommodated by the state unless the strict scrutiny test applies. Here, there is no compelling state interest because free exercise of religion is more important than raising of revenues and regulation of businesses. Hence, the society cannot be ordered to procure the mayor's permit or license. In INRE, letter of Tony Valenciano, Valenciano complained about the holding of masses during lunch break at the basement of the Quezon City Hall of Justice. Should the activities be stopped? No, the holding of masses during lunch break is a form of religious expression. Under the doctrine of benevolent neutrality, religious expression must be accommodated by the state unless the strict scrutiny test applies. Here, there is no compelling state interest because public service was not disrupted by the masses during lunch break. Hence, they should not be stopped. Next, the state must also be prohibited from meddling with the internal or purely ecclesiastical affairs of religions. So why? Internal, purely ecclesiastical affairs of religions are covered by the Free Exercise Clause. Ecclesiastical affair involves the relationship between the church and its members, and it relates to matters of faith, religious doctrines, worship, and governance or congregation. Examples are proceedings for excommunication, ordinations of religious ministers, administration of sacraments, and other activities which attach religious significance. So in short, relationship between church and members, plus relationship to faith, doctrine, worship, and governance of congregation cannot be regulated by the state. So next, civil courts will not interfere in the internal affairs of a religious organization, except for the protection of civil or property rights. Those rights may be the subject of litigation in a civil court, and the courts have jurisdiction to determine controverted claims to the title, use of possession of church property. The application of purely ecclesiastical affairs against governmental acts. If the dispute is between the dismissal of an employee, a janitor, and a religious organization, the state can interfere because this is a labor dispute. Okay, it can be a civil or a property right. You may check Pastor Austria versus NLRC, the 1999 case about this. In the case, Pastor Austria was not excommunicated from the church, but was terminated from employment. The grounds invoked for the dismissal are all based on Article 282 of the Labor Code on just causes. Hence, it was a labor dispute and not a purely ecclesiastical matter. Okay. If the dispute is between the expulsion of a priest and the religious organization, the state cannot interfere because this is a purely ecclesiastical affair. Lastly, the non-religious test clause. No religious test shall be exercised through political or civil rights. Okay. So, that's all about freedom of religion. But before we end this, I'd like to just add one more case. So this case is Estrada versus Escritor. So here, Alejandro Estrada from Bacoor, Cavite, against Soledad Escritor, the court interpreter of the Regional Trial Court of Las Piñas City. So here, Estrada filed the charge against Escritor via a sworn letter as he believes that she is committing an immoral act that tarnishes the image of the court. Thus, she should not be allowed to remain employed therein as it might appear that the court condones her act. The judge stated that there is no truth to the veracity of the allegation and challenged Estrada to appear in the open and prove his allegation in the proper forum. The respondent shared that she is a widow and living with a man named Luciano Quillapo Jr. for 20 years without a benefit of marriage and that they have a son. Respondent is a Jehovah's Witness and their conjugal arrangement is in conformity with their religious beliefs, hence sharing the signed declaration of faithfulness. So, the declaration thus makes the resulting union and binding within the congregation all over the world, except in countries where divorce is allowed. So, based on the tenets of Jehovah's Witnesses and as a matter of practice, the marital status of the declarants and the respective spouses' commission of adultery are investigated before the declarations are executed. As per the Jehovah's congregation, there is nothing immoral about conjugal arrangement between Escritor and Quillapo, and they remain members in good standing of their congregation. So the issue here is whether or not respondent should be found guilty of the administrative charge of gross and immoral conduct. The ruling of the Supreme Court is no, the respondent should not be found guilty of the administrative charge of gross and immoral conduct. The court held that in resolving claims involving religious freedom and basing the decision after a long scrutiny of the origins and development of the religion classes of the United States and the Philippines, benevolent neutrality or accommodation, whether mandatory or permissive, is the spirit, intent, and framework underlying the religion clauses in our Constitution, and in deciding the respondent's plead of exception based on the free exercise clause, the compelling state interest test must be applied. So, yun pala, since Jehovah's Witness nga sila, so yung kanilang agreement in the church is binding to the whole world except for countries which accepts divorce. So, there. Thank you for joining me in my review session regarding the Section 5 of Article 3 of the Bill of Rights, which is the freedom of religion.